Welcome to Criminal Law Unfiltered.
Welcome to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group, and for over 4 decades, he's defended thousands of clients in both state and federal courts. He's known for building strong strategic defenses when everything is at stake. I'm Evan Mack, and in this episode, we're continuing our conversation about jury selection, the strategy behind it, how prosecutors and defense attorneys approach it differently, and what it means for defendants and their families. Robert, sir, welcome back.
Hello.
How you doing? Listen, Robert, we talked about it in the first part. We kind of broke it down. This is going to be a little more in depth, I suppose. Robert, how do judges influence the jury selection process?
They can influence it tremendously.
Interesting.
And that's something that you need to be aware of. I've had, homicide trials where the judge just backed away and let me say whatever I wanted to, or ask whatever I wanted to. And then I have a trial recently where His Honor, he tried to stop me at all costs. And the DA wasn't objecting. And, he was, but he's didn't want me going in certain directions. And my questions I didn't think my questions were illegal or against California law. I thought the questions have to be designed to uncover whether somebody can be kicked off the jury for cause. Kicked off was not the word I wanted to use. I couldn't think of another one, but kicked off the jury or disqualified for cause. And normally, and so that's how you have to phrase it. You have to phrase it as a question looking for bias in order to disqualify them. And so a judge can stop you in mid-sentence, say, Mr. Helfand, that's an improper question, especially, if you have a DA that's going to do the same thing. So I've had a lot of cases where the judges just say, let the attorneys, do their thing, so to speak. And I've had other cases where the judge gets involved and stops me. And when that happens, I'm not going to get the jury that I want. That's for sure. So there are certain jurors that I'm looking for, but you like to start with the theme of your case in jury selection. That's what I do. I get the theme of the case out there and judge the reactions of the potential jurors to my theory of why this happened. And if it happened this way, would you have a problem finding somebody not guilty? I mean, that's, in a general sense, that's what I try to do.
So, Robert, what about this, though? How do prosecutors and defense attorneys usually differ in what they want from a jury?
It's like night and day, what they're looking for and what I'm looking for. What they're looking for is people basically who are not biased against police. Because let's face it, most people, when they come in there, they look at your client. Oh, he or she must have done something. So they come in with actually the advantage, especially in federal cases. They come in with the advantage. And so prosecutors are looking for people who haven't had a bad experience with law enforcement, like during a traffic stop, that have no family members who are in prison, who they feel were unjustly imprisoned. So that's what they're looking for. And defense attorneys are looking for, I don't know how to generalize this, but it's much more of a liberal-minded person.
Okay.
An open-minded person that could say, I'm not, if you're going to just, you're looking for people that will look at the evidence, okay, and yeah, you know what? Here's what he brought up, meaning me. This is what he brought up during the trial. And it makes a lot of sense.
Hmm.
So we should take a look at that. We should take a look at that. And so it's not necessarily so cookie cutter for me. It's more cookie cutter for the people. And my last two murder trials, and it was with the same office, with the same branch.
Wow.
The DAs, and they were homicides. The DAs in each one of them accepted the panel so freaking early. So in other words, when you have a jury trial, depending on the type of case. So if it's a homicide, it's a life case, potential life in prison. So you have more what are called peremptory challenges, meaning I can kick you and it's not for cause. It's not because you can't hear, so it's for cause. It's not because you don't understand English, which would be for cause. It's for other reasons that I don't have to disclose. And so I have a lot of them. So on a life case, you get 20. And the last trial, even in the one before that, the prosecution used maybe 3 or 4. And then they're sitting there and they accept the panel. So what happens is once you're done with your questions, the court, his honor or her honor, turns it over to the attorneys. And you're asked if you pass for cause, if either of us, both of us pass for cause. For cause is different. For cause is something we would normally agree on. Oh, they don't speak English. Oh, they don't understand English. Oh, they can't hear. Something like that. Or sometimes certain hardships where you could tell, look, Your Honor, they have that doctor's appointment. Their mother is ill. Let's just let them leave. After you get past that, then you do the peremptory challenges, and it starts with the defense, and then it goes back to the prosecution and back and forth. And so, after about 3 or 4 of those, and then your prosecutor is saying, Your Honor, we accept the panel. It's crazy. Really? You're going to accept the panel. Okay. But that is that answers your question, because you're saying, is a difference between the prosecutor and the defense.
Mm-hmm.
What? I would never do that.
Yeah.
Okay, they just accept the panel because they look at these people, they ask a few questions. I know you're with me because you're law and order people, and I'm the prosecutor, and I'm supposed to win. And whatever I say, you're going to believe me. He's the defense attorney. Don't believe anything he says anyway.
So in your experience, though, Robert, like what traits make a juror more open to the defense's case, to a case like yours?
What traits? It's kind of hard to say. What traits? You have to speak with them and see if you can. When you speak with them and you have that little few moments of connecting with this person, whether you feel this connection and whether you feel they are connecting with you, it's just kind of, a back and forth you have with them. But as you're asking them questions, you're also aware of what are the body movements of the other panelists to see what they're doing as well. And inevitably, when you are picking a jury, you will come and you will find somebody who, like the last trial I was thinking of, there was a woman who was basically saying, my client had tattoos. And so I was asking about tattoos and whether or not, do you think if somebody has tattoos, that means they're more predisposed to committing a crime? And this woman, I believe that's what it was saying, if you have a tattoo, you're definitely more predisposed to committing a crime for sure. something like that. And she was adamant about it. And, you know, I wasted a little bit of time talking to her, just kind of, and I think some of the things I asked her was that you really don't want to be on this jury, right? I mean, that's why you're saying that, because you really don't believe some of the that you're telling us right now, right?
So when you're handling these, different types of defense, self-defense or whether putting the client on the stand, how does that change your view on the selection if you think you might have to potentially put your client on the stand?
Well, on a homicide case where you're asserting self-defense, more than likely, you have to put your client on the stand. And so I don't know that I so much ask them talk about, well, what if he didn't take the stand? Because the judge does that. The judge each judge has certain kind of standard questions that they ask before they turn the jury over to the attorneys. And one of them is, if the defendant didn't testify, would that, affect your ability to weigh the facts or to be fair in the case? So that's kind of taken care of. But normally you have to put your client on the stand because the client has to assert their self-defense rights, because at the end of a trial, what happens is the judge reads the jury the law, and the law on self-defense, and the judge will lay out the law of self-defense and when is deadly force lawful. Plus, the judge will give instructions on lesser included offenses for like voluntary manslaughter. Like the last trial, I even got an involuntary manslaughter instruction. And even though I'm not sure the facts really supported it, but might as well put that in there. But so you have to put the client on the stand, because the client has to say to the jury, I felt my life was in immediate danger. Without that statement that they felt their life was in immediate danger, then there is no self-defense. So, I'm trying to think if I've said any questions like that. I don't normally kind of get into that with a jury, about or letting him know my client is going to testify. I don't normally get into it because I'm actually getting into the theme of the case and not, well, there is one way that I do it. So let's assume that you have a client who has a prior conviction, okay? Right. Prior felony conviction. And then they used a gun in their self-defense. The way that I got to that was, so in a jury trial, jurors never know about a client's prior convictions. Doesn't come in. And they never know that, because the system wants you to judge somebody based on the conduct that happened in front of you. What is this? And so knowing that somebody has a prior conviction, that could sway you against them. So a jury doesn't normally know about a prior. However, if your client gets on the stand, I've had homicide trials where I didn't have to put my client on the stand. The court had told me ahead of time, okay, you've established through other witnesses that your client felt that their lives, other people's lives, were in danger. And it was clear that the victim, the so-called victim in the case, was threatening them with deadly force. So I didn't have to put my client on the stand to say, yeah, I saw my family members were being threatened with deadly force, so I used a gun. I didn't have to do that. However, in the trial, my questions were basically, one, under what circumstances, juror number 2, would you think that deadly force is appropriate, lawful? And they tell you, well, defending yourself, somebody coming into your house, or defending a family member. Juror number 2, yes, defending a family member. You think that you could use deadly force if a family member was being threatened with deadly force. That's what you're saying, right? Yeah. Okay, so let me add another layer to that. Would you still be able to be unbiased in your analysis of the facts that somebody was justified in using deadly force if I told you this? What if I told you also that the person that used the deadly force was prohibited from possessing whatever instrumentality that they used? And I'm not being specific because you can't be specific to the facts of your case. So you have to say it in a different way, which is how you'd say, what if that person who used the deadly force was prohibited from owning or possessing or using like a knife or a club or a gun, something like that? What if they were not allowed to have that? Would that affect your ability to analyze whether or not deadly force was appropriate? And so then you get the response from them. Okay. And that's what you're looking for, because I found out about this at dinner parties, oh, Mr. Rob, hey, what's your latest case or whatever? Okay, well, I got this homicide and this is what happened. The knee-jerk reaction at the table is always, what was he doing with a gun?
Right.
And so I go, well, guess what? You're not on my jury, okay?
Yeah.
Okay. I didn't talk about, that's not the point. The point is not why he had a gun. It's whether or not he was justified in using the gun that he had. It's a good thing he had the gun. Otherwise,
he'd be dead.
And so that's kind of how it works.
Wow.
And so that's how that's kind of the roundabout way.
Yeah.
I don't know if it's roundabout, but that's how you kind of see how your client, or see how your potential juror would look at your client and find out that this person has a prior, because it only comes out if they take the stand that they have a prior.
And before we wrap things up, though, Rob, what's the single most important thing for someone facing trial to know about how their jury is chosen?
Honestly, it depends on whether it's federal or state, because federal is the system is completely different. I don't know if we talked about that last time. The judge asks the questions, and so it's very difficult to get any kind of connection with your potential jurors because you're not allowed to talk to them. In state cases, the most important thing is for, I don't know what the most important thing is. It's very hard to be a defendant in this system. They have to sit next to you, and it's a hard place to be. I feel empathy for them. And if you don't have empathy as a human being, then you're an empty person. And that's what one of the qualities I'm looking for in a jury is empathy, because the person sitting next to me, think about it. They're helpless. I mean, they're relying on me, and what I want them to be is involved. Okay. I want them to be involved. I want them, they could take notes. I like the notes. That's fine. Give me the notes. Don't talk to me. Give me the notes so that I could read them. Because if you talk to me, then I'm having divided attention. And, when we're picking jurors, I always consult with the client. I go, look, this is what I'm thinking. We're going to get rid of this person. Now, look, this is the one who's going to take the place. And then I don't like the person that's taking the place. So we're going to get rid of that one to get this one. And, it's very difficult for them. And I try to advise the client, try and stay neutral and don't show emotion. Okay, don't show any emotion. If you're going to take the stand, they'll see what you're like, but don't show emotion. Don't shake your head. Don't stick your tongue out. Just stay there, and we'll converse, you and me.
Good stuff. Rob, thank you for the time, brother.
All righty.
Thank you all for joining us on Criminal Law Unfiltered with Robert M. Helfend. Jury selections can shape the entire direction of a case, and having an experienced attorney makes all the difference. If you or a loved one are preparing for trial, visit robertmhelfend.com to learn how Robert and his team can help. Don't forget to like, subscribe, and leave a review. If you found today's episode helpful, thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.